Thank you very much, sir. Sir, this is a bill purposed to modernize our immigration framework by consolidating four pre-independent legislations with a single comprehensive framework governing the entry, exit, stay of foreigners in our country. Sir, already Manish Tiwari ji has pointed out the apprehensions and concern because how this law can be misused by the authorities on the basis of the past experience. Sir, clause 3.1 proviso, first proviso to clause 3.1. I'm not going to read the provision that it gives the government absolute discretion to prohibit the entry of any foreign national, including persons of Indian origin based solely on the ground. It is a threat to national security, sovereignty and integrity of India and relations with foreign state, public health and such other grounds as the central government may specify in this behalf. So any other grounds, whether according to the whim and fancy of the central government, can be decided that he can be denied the entry or stay, and all these issues can be done. Sir, in recent years, we have seen that instances where the government invoked national security as a pretext to target the political opponents and the critics. And we have so many bitter experiences. Then normally the Honorable Home Minister may reply that this is a law which was made during the past years. Even the Carriers Liabilities Act was passed in the year 2000. But when we are making a law in 2025, definitely we have to be more reformed. We have to safeguard the principles of natural justice. We have to safeguard the civil rights and protect the democratic rights of the citizens and the citizens, including the foreigners, whoever it may be. Sir, recent experience that the case of Kashmir Sawant, who was denied visa to India to visit her mother in Bengaluru, that was been denied on this ground, and she has returned. She has quoted in the Twitter that is reject. I am in the rejected list. So that shall never happen. That is my suggestion, submission. And second one is regarding clause 7 of the bill. Government may by an order or direction or instruction make provisions either generally with respect to all foreigners, with respect to a particular class of foreigners, and prohibiting, regulating and restricting the entry into India. Sir, in this case, I would like to draw the attention of the Honorable Home Minister. Previous law, there was only order. Now we have put two more words, direction and instruction. If it is an order, then the order has to be placed before the Parliament, before the House. If it is an instruction or direction, that need not be placed before the Parliament. That means the government is evading from the Parliament, placing the matter before the Parliament. That is why the two new words are incorporated in the new act, that is direction and instruction, along with the order. That is also has to be explained by the Honourable Minister. This provision is also giving arbitrary powers to the government and selective exclusion of individuals or class of persons by prohibiting, regulating, restricting the entry into India on political and ideological grounds. This is against the principles of equality and justice guaranteed by the Constitution. And sir, 3 is, okay sir, I will within 1 minute I will conclude. The mandatory reporting obligation under clause 9 and clause 10. Universities, educational institutions, hospitals are mandated to furnish the details of the foreigners to the registration officer. Sir, imagine a professor or a medical researcher or a family is forced to submit the personal information to the government simply for the reason being a foreigner is not good. It is against the principles of the right of privacy as well as the only because of the reason foreigner that will not hold good. It is violation of the right of privacy also. Sir, coming to clause 16, that is the burden of proof which has already been mentioned. I am not going to repeat it. Sir, regarding the burden of proof also, it is being also burden of proof is on the person who has to show, who has to prove that he is not a foreigner. So this is absolutely not fair. I am with the concluding sentence regarding the clause 26 also, because the police officer, formerly it was a sub-inspector, now it has been made as a head constable. Arrest without warrant by a head constable means that has to be relooked. And the economic, so sir, and concluding, the social and economic impact of this amendment is too much, so that has to be considered because the economic prosperity as well as the tourism potential and the investment destination that will be affected. So this is to be sent to a standing committee or a select committee for further scrutiny. With these words I conclude. Thank you very much, sir.
Thank you.
No, he is not there. I think. Call the next.
माननीय श्री उमेश पटेल जी।